Thank you for your message too.
You guys don't have to sign up. I'll give you that.
Are we ready? Is it started? Okay, we started. Please call to order.
I now call to order the meeting of the Folly Beach Board of Zoning Appeals on Thursday, May 19th, 2022. The minutes of this meeting and results of any votes are available for public review and subject to the Freedom of Information Act. Any citizen wishing to examine these records should inquire at City Hall. I'll now ask the secretary to call the roll, and Erin has requested you raise your hand so she can put a name with the face.
I'll call the roll. Tony.
Oh.
Ms. Cato.
Here.
Ms. Denninger. Mr. Gunn. Mr. Miller.
Here.
Mr. Stevenson. Ms. Brown. And Mr. Rosen.
As we move to the cases being presented tonight, I would like to remind those giving testimony that the BZA is a quasi-judicial body. We must base our findings on the law and the facts presented as evidence during the hearing. Furthermore, the evidence entered tonight, as well as the findings of this board and transcript of the meeting, will constitute the record should an appeal be made to circuit court. I'll now ask anyone presenting evidence or testimony of the board tonight to please raise their hand and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Thank you. The first item of new business is a request for a variance at 1579 East Ashley to allow the construction of a new home with a 5-foot front setback. For clarification, the tax map number of the property we are discussing is 439-14-00-045. The property owner is Marguerite Von Glon, and the applicant is Adam Baselow. Specifically, relief is being sought from table 165.01, which requires that new construction have a 10-foot front setback. Because this is a request for a variance, I will remind the board that we're required to establish that the property in question meets the criteria stated in the state law in the Folly Beach Code of Ordinances. The applicant's case, as well as a recommendation of staff in regards to these criteria, are in the packets submitted for our review and will be presented tonight. Board members should refrain from making any comments and asking questions during the initial presentation. After we've heard from the applicant, staff, and any members of the public who wish to comment, I'll ask for a motion to grant the variance. At this time, the board shall then have the opportunity to discuss any motion made. The board will also be able to ask questions of staff or the applicants. Once all questions have been asked and answered, we'll vote on the motion. A copy of our decision and the findings will become part of the record. Before we hear from the applicant, I will ask staff to review the packet for the meeting and discuss the evidence submitted.
Okay. You have the agenda and the notice that went out to the neighbors and what was submitted to the public. The affidavit of publication is from the Posted Courier. It was where it was noticed that they published this 2 weeks in advance, 15 days in advance. The affidavit of mailing is that the affidavit of mailing shows that we sent out the mailing to the people within 150 feet of this affected property. The third picture is a picture of the notice as it went up on the property. Then you have this is the affidavit that administrative ownership or control by DHEC.
And so what that is the authorization showing that Margaret Von Vaughn is the owner of B Holdings LLC has the right to represent the
Then you have the submittal by the applicant that says variance request at the top, and dated March 29th, 2022. It is pretty thorough. So flip back towards the back. And then you'll come up with the staff report. And after that will be emails from Sheldon Litwin. That's the email from him and the 2-page document that he sent in, and the picture that he sent in. And there are 2 other emails, one from Bill Palace and one from Cassie Pittman. Those were the 3 emails that we received.
Okay, does everyone have everything? We'll now hear from the applicant regarding the variance request. I ask the applicant to come forward and state his or her name and address for the record before beginning. Please be aware that you're allowed 10 minutes to present your evidence.
Good evening. My name is Adam Baslow. My address is 3212 Eames Lane on Johns Island. And I am the applicant. I'd also like to have my attorneys take some of that time if that's okay, because the team helped put this together. But as you guys may or may not be aware, we've been working on the property for quite some time. It's an extraordinary lot with a number of circumstances, from the pocket lot, perpetual easement line, the DMA shifting a few years ago, and some of the ordinances that have changed. We've spent a considerable amount of time and effort and energy trying to design a house that would be in keeping with Folly Beach, that would not be larger than the adjacent properties and would minimize the impact to the buildable area of Folly, while protecting the dune, the natural resources, and the beach itself. As I think the staff can share, we designed at least 2 plans that they've seen in their entirety, and worked with staff over the past 2 years, going back and forth with what would work, what would not work, and what variances we would need to request in order to design something in keeping. What we had to do first and foremost was work with the state to get a special permit to build seaward of the baseline. This is one of the last pocket lots on the beach. After that, we had to work with the other side of DHEC with the state to secure a septic permit and know what our areas would be, and then we designed a house. Only to find out that what we designed, we couldn't ask for a variance because the septic area was going to be encroaching into the DMA. And we were told on that submittal that was not even able to be requested for variance. So we went back to the drawing board, looked at the configuration and the parameters, designed something, went back to the state, worked with DHEC OCRM on that, and got that approval for a revised special permit. Then, with a smaller footprint and a smaller house, we went to the other side of SCDHEC to secure a septic permit, and then submitted this to meet with staff and work through the application you see in front of you. I'd be happy to answer any questions later on as the time permits, and at this time I'd like to turn it over to President.
Good evening. I'm sure everybody's excited to have a lawyer up here. I told Adam when we come out, I said, buddy, you're talking first because they don't want me up here. I can assure you. But I appreciate everybody's time. I know these meetings on Folly Beach don't happen that often, but when they do, it's important that we're all fully engaged. So I'm not sure how many folks on the board are familiar with the pocket lots on Folly Beach. When OCRM established the baseline for Folly Beach as a result of the jetties work, the baseline of Folly Beach was established just seaward of all of the existing homes. At that time, there were 5 lots on the front of Folly Beach that had not been built on. Those lots had their baseline come all the way back, in this case to East Ashley, to the road. The remaining properties that had homes, the baseline was established just seaward of those homes and not encroaching into those homes. 4 pocket lots have been built on Folly Beach. That's why Mr. Basil had to get a special permit from OCRM to build seaward of that baseline. When the Corps of Engineers established the perpetual easement line on Folly Beach, they used the baseline that OCRM set to set the perpetual easement line. What do you do on this lot? Well, this is a really, really unique lot in that the property to one side, the home on one side, is set back further from the beach than the home on the other side. So to connect those points, they just arbitrarily decided to draw a diagonal line. The result of that on this lot is to cut the lot in half. With Folly Beach's passage of the dune management area, the setback from that PEL line was moved from 5 feet, which it had been, to 40 feet. So now that line and that setback is 40 feet further towards East Ashley, reducing the buildable area of this lot by some 75%. Looking at that extraordinary and unique situation on this lot, Mr. Basil worked very tirelessly with staff to come up with a design that would work in keeping with the zoning ordinances, would fit on the lot, and most importantly, at the advice of staff, would not encroach into the dune management area. The idea being there would be no encroachment into the area protecting the dunes. There is no dune that's going to be impacted. There is no building that's going to be on the beachfront. This home has been uniquely designed to stay more than 40 feet behind the easement. And if you look in the packet and what was submitted, and I can't tell you the page number, it was one of the exhibits we submitted. The homes along this stretch of beach, almost every home on either side of this vacant lot, the homes sit majority within that 40-foot setback. They were existing, so they're deemed existing non-conforming. If those homes get knocked down in a storm, those owners are going to have to build behind that 40-foot setback. Mr. Basil has designed his home to fit behind the 40-foot setback so that if his home was destroyed in a terrible storm, he could put it back. The circumstances of this lot are unlike any circumstances on any other lot on the front beach. There's been a tremendous amount of effort to make sure that the nature and the vibe of Folly Beach is kept the same. There are concerns about environmental impacts. I spend about 85% of my practice doing environmental law, so I can answer those questions if you have. The setback and the variance requested is a 5-foot encroachment into the 10-foot front yard setback. What that means is, at this lot, the home will be 5 feet into that setback, which is 10 feet from the property line. It is not 10 feet from East Ashley. The right-of-way for East Ashley in this area, and staff correct me if I'm wrong, is 75 feet. There's a 50-foot right-of-way because it's a state highway, and the city of Folly Beach has 12.5 additional feet on either side. This house does not come near that. This house will be 5 feet further. So if you split the difference and assume that East Ashley is right in the middle of that, this house is going to be on order of 32 to 33 feet away from the road. It will not be sitting on the front of the road like a Charleston single home. There will be a front yard. There will be consistent with homes directly across the street that already sit right at the property line, yet are still set back from East Ashley. This home will be further from the road than those. 1578, I believe, sits right at the property line. That's across the street. This home will be further away from the road than that. These are unique. This is a unique lot. There is no other lot on the front beach of Folly like this with this many restrictions. And tireless time, effort, and money has been spent to make sure that this house can fit, will keep within the zoning restrictions, and has the minimal impact to any of these setbacks as possible. We've maintained setbacks from the neighbors, so there's no encroachment on an adjacent property owner. We've maintained the beachfront DMA setback at 40 feet. We've had a septic system designed that's higher quality, can fit in a smaller area. It's been approved by the state. The state has approved the building at the beachfront. So we're here asking for a variance to encroach 5 feet in the front yard, not anywhere else, to not affect anyone else. Like I said, I'm happy to answer any questions and would ask that if there are issues brought up in opposition, that we have the opportunity to respond. Any questions?
It's not time for questions.
Oh, okay. All right.
Okay, we'll now hear Jenna's presentation of facts and her recommendation. Would you come forward and state your name and title for the record? Please be aware that you're allowed 10 minutes to present your evidence.
My name is Jenna Stevens, and I'm zoning administrator for the city of Folly Beach. Can you speak up as well? Yes, my name is Jenna Stevens. I'm the zoning administrator for the city of Folly Beach. I'm going to go through the criteria here and the staff report that I created. The first criteria is extraordinary and exceptional conditions. This property is unique because you can see where the perpetual easement line goes through the property. It basically bisects it in half, and the properties next to it do not have this same orientation. They have more of a parallel perpetual easement line, and the Part B, the circumstances here arose. It's not a part of the result of the applicant. This is when the Army Corps of Engineer came in to create the perpetual easement line. That is what created this unique circumstance here. And then the resulting 40-foot setback from the Dunes Management Act were created by the city. Construction of this home that adheres to this required 40-foot setback isn't achievable. It's just without a variance. This property is rendered economically useless. There's so much space that is taken up by the setback that no home would be allowed to be built here. And the applicants, as they said earlier, have submitted several, I think 3 proposals to the city staff that tailored this plan based on the staff comments. They revisited those options and reduced the number of bedrooms, reduced the number of parking spaces, and they were only, this version, encroaching into the front yard setback. Previous plans did encroach into other setbacks, the required other setbacks. So this iteration that they have is the maximum necessary to reasonably use this land. And this would not result in substantial detriment to the resulting area. The other houses along here are single-family resident lots, and so allowing another single-family resident in this family of beachfront lots is in character with the nearby neighborhoods, the nearby residences. And the granting this variance would be consistent with the purposes and the intent of the CDO This ordinance specifically says that preserving the character of the neighborhood is one of the purposes of the ordinance. And this property would create a property, this variance would create a property that would allow preserving the character of the neighborhood, as it looks just like all the other lines are very similar to what's already there.
Thank you, Ms. Stevens. At this time, we'll hear testimony from those members of the public who've signed in to speak, and read any testimony that should be submitted in writing to the record. If I can, let's have Logan Davis. And they have you have 3 minutes apiece.
Piece or landowner that I'm here for?
You have 3 minutes.
Okay. You sure? Okay, I appreciate everyone's time allowing me to speak today. I'll try not to run up on my 3 minutes with those words, but anyhow, I'm here on behalf of a few different homeowners around the subject property here, and I'll try to just be brief as to why we oppose this variance. First and foremost, I heard a couple different things through the different presentations, such as, this will be aesthetically pleasing, this will preserve the character of the neighborhood. I tend to disagree there, and I think a lot of neighbors do. Looking at the plat, and I hear what has been said about the right-of-way, but the right-of-way is there for a reason, right? I mean, it's for future development. It's for sidewalks, maybe expansion of the road. Hopefully we don't have to do that anytime soon, but that's what it's there for. Nevertheless, other neighboring lots have a lot more aesthetically pleasing features, such as greenery, plants, things of that nature. And so it will not be in line. I mean, if you just look at the parcels, I disagree that it will match and fit the character of the neighborhood. So that is one issue. That aside, I heard discussions about this perpetual easement, and I'm looking at that here, and gosh, yeah, I hear that it was just a diagonal line drawn in there, and that's fine, but aside from that, nobody brought up the fact that there's this landward toe of a primary dune that was marked in October 2020. That was obviously, looks to be an issue because that's where they try to butt up to. It's my understanding that there's another baseline survey due to come out in 2024. Why rush this? Let's see where that is. Obviously, the water is rising. That's nothing new. We've seen that all over Charleston at this point. And I think that, maybe give it time. Let that drawing come out, see where it lies, because I have a feeling that that's going to encroach way further up than the 2020 map or that we've seen. So, that's an additional issue. Aside from that, it's my understanding from talking to additional other folks that there's potentially an issue with disruption of turtles on the back end of that parcel. I don't know that to be fact, but that's just another thing I'd like to mention in my discussion. Additionally, I would almost contest this plat because I believe it should have markings of the rocks that abut the parcel. If you're looking at the subject parcel from East Ashley, I believe it's to the left. And I don't see, and I could just not be seeing it, but I believe there's rocks that are there to preserve the property next door. So I think you have an issue there. We talk about septic. I believe that's going to run right up on it. You're going to have to remove those rocks, and that's going to be a major issue for the neighboring parcel. So, I just don't see that marked on there, and maybe it didn't need to be, but I think for transparency, maybe it should have been. And again, going back, this lot was undevelopable at one point, and yeah, sure, there's been a special condition permit, and I'm sure y'all are aware of what's going on, but just briefly, you know, basically it says in the event that
Excuse
the
me, Chairman,
beach.
he's significantly over time.
Thank you.
Can I speak on behalf of another neighbor?
Are they here to cede their time to you? Do you have anything in
We
writing?
have 10 minutes total.
3 minutes.
No, you have 3 minutes, and if he speaks for you, that's your 3
Yeah.
minutes.
I'm gonna let y'all speak, because I think it's
Okay.
important. But I'll just wrap up with this, you know, obviously, there is a special permit because there's issues with this property. Like I said, I don't think it's gonna be aesthetically pleasing. I don't think it's gonna preserve the character in the neighborhood. I think there's a lot of neighbors that feel the same way about that. Thank you for your time, and I apologize for running over.
Thank you. And y'all are Sheldon and Christine?
Yes.
Okay. Let's have Randy Walker next. That's who signed up.
Thank you. First of all, this is my power of attorney from the adjoining neighbor at 1581. I speak for Catherine MacArthur, who purchased the house on the east side some 20 years ago. At the time, there was a rock revetment wall that went seaward of her property and then went down the side of her property where this adjoining lot or owner has intends to build a house. She's been asked by a prior attorney to remove the walls, the rock revetments, and has declined. In fact, she claims adverse possession. The permit that was submitted to the OCRM shows the property with a septic tank that actually intrudes into the 10-foot side setback line. It shows a primary dune where the house sits right up on the primary dune. I don't have pictures of the turtle nest that was there this past year, but I've seen it before and I can also provide it if need be. Also, these are pictures of the rock wall as it runs down the line, and it also sits on, not only on the property line, it's about 15 feet wide and about 15 feet deep. And there's a whole bunch of them. I'll read from you a bit of her request. And I will tell you that I'm also own a company called Dunes Properties about 3 doors down the street. And the mayor keeps calling Dunes West, but it's Dunes Properties. I don't know if he's doing that on purpose or not. But, this house is proposed to be built in an area that is established dune that had a turtle nest on it. This plot was supposed to be unbuildable because of the placement of the high tide lines by the OCRM. It was noted in county records as an undevelopable property, and that was the basis of her buying that property. Not only did it protect her from the front, but on the side. Those rock walls run all the way down to the street and across the front of the property on the street. The OCRM's no construction line actually goes beyond the platted property on the street, on the lot, and into the easement between the street and the front of the property. The plans that are drawn would allow the septic system to breach the required side setback lines that adjoin our side property line. That rock wall must not be disturbed. It would take away her rightful protection. But to build that septic tank, within that, she'll have to claim adverse possession and created probably a, what do you call it, an injunction to stop this construction. A prior attorney had asked them to remove the rock wall, and she refused and said that the rock wall was built on to protect our property many years prior to our own purchase of the property, and it has been in place and open and obvious for years. Therefore, the property that the rock wall sits on is now part of our lot by adverse possession. In South Carolina, the law of adverse possession is codified by South Carolina Statute 15-670-210 and states that property that is held by another person who doesn't own the property for a period of 10 years is in open and obvious manner becomes the property of the non-owner. It's her possession.
Your time is up.
Oh, well then I apologize for taking too much time.
Thank you. Okay, Sheldon and Christine. Litwin, is it
Yes,
Litwin?
Litwin. Hi, my name is Sheldon Litwin. We are the owners of the property across the street at 1580 East Ashley. So we oppose this development for aesthetics, social, environmental, economic concerns. So I just took this quote from the visitfolly.com website. It says, Folly Beach is one of America's last true beach towns, just minutes from historic downtown Charleston. It's a funky, laid-back, come-as-you-are kind of beach. I think the idea of pushing houses close to the road violates the ethos of that, which we use to bring people to Folly Beach. It's why people move here. It's why people visit here. And we think that pushing houses closer to the road is something we expect in crowded urban areas, but not on Folly Beach. It's not something that we want to see. In addition, we think if you approve this request, then it opens the door for everyone down the line that wants to tear down a small house and build a bigger house and push it closer to the road and ask for an exemption for an ordinance. That it's going to be very hard to turn those down once we start going down that path. The lot's too small to build on. There's severe beach erosion there, which has proceeded just in the couple years that we've owned, and we get to see that regularly since the last renourishment. That poses a problem with storms, and it raises insurance rates. It's a problem for all of us that live here when houses are built into these erosion zones. The lot did contain an active turtle nest last year. I actually have a picture of it that I submitted to you guys that you can look and see, and that was just the slab this past fall. If we build onto that and encroach on the dunes, that area is forever lost for turtles and for any other species. The septic tank poses a risk when the floodwaters come in into that area, then all the creatures and the people that precious plants and things that grow on the dunes are at risk as well. The Morris Island Lighthouse is one of the most iconic landmarks in Charleston. Thousands of people travel down that road every day to get down to the north end. It's the only way to get there. And seeing these houses that are pushed closer and closer to the road, I think is a detriment. To us, to property owners there, the closer you put a house to the road, the more it obscures views of the ocean, and that's just a principle of physics. So that matters to neighbors, it matters to people that use the road. The road is used by cyclists, walkers, cars, all sorts of vehicles. Everyone suffers from having a close house that is pushed up there that doesn't fit with the character of the neighborhood. The cityoffollybeach.com website says the beach is our most important resource. It's valuable not only as a barrier against storm damage and as the economic engine of the city, but as a recreational area for hundreds of thousands of people each year and a habitat for a variety of wildlife. Examples of ordinances designed to preserve and protect the beach include lot coverage, maximum house size, setbacks, rules for non-conforming and non-compliant structures, minimum lot size, new seawall ordinances, etc. So we believe that a house this close to the road, again, violates all these principles and what we want Folly Beach to be.
Your time is up.
Okay, so just in summary, for a wide variety of reasons, we and most of the neighbors that are in this area oppose the development of this house. And I would also just argue that the lot is not unusable, it's just unbuildable.
Thank you. And C. Matt Gibson.
Good evening, I'm Matt Gibson. I do have a speech impairment, so I'll just ask you to bear with me. I'm an attorney for Folly Beach, so I'm here to speak on her behalf. Ms. Bonglon is almost 100 years old, so she resides at an assisted living facility right now, so she wants me to be here on her behalf. One comment I'd like to bring out is the issue about adverse possession. There had never been any lawsuit filed against Ms. Bonglon after any adverse possession. So there's nothing pending, so I'm not sure that what he said should carry any weight, and particularly the use of an injunction. The fact of the matter is, Ms. Bonglon bought the property in 1952 or 1953 in good faith at the purpose of investment. She's been paying taxes for all these years. And so it's the expectation that she's going to reap some benefit from this. And she is going to need some security by way of selling land for her future years. There's no telling her pedigree of family members have lived a long time, so she's going to need some security. But going back to the point about the unbuildable lot is that has no legal distinction, and there's no legal basis to declare a lot unbuildable by somebody down the Charleston County office. And the mere fact is that unbuildable, my client would not be paying taxes all this year. And I have watched the Adam, along with the staff member of Folly Beach, and I compliment them on what they have done and how they have advised Adam in his journey on how to proceed with it. So I would ask you on behalf of Ms. Bonbon if you would approve their variance. And if you have any questions, I'd be glad to answer them.
Thank you.
Thank you, ma'am.
I wanted to read these emails, but I can only find one from Cassie Pittman. This one is not signed by anyone.
This
or
one was an
couldn't find-
attachment from, the Woodlands.
Kathy Pittman?
Here's the red one.
It's the last page. Maybe it wasn't included on yours.
Okay, so all this goes together?
Yeah, Cassie Pittman's one.
I have hers.
Okay, Bill Palace is another
I
one.
don't have his.
Okay.
And then,
And then there's the attachment came from the Woodlands.
I've got two Pittmans and I don't have a Lippman.
An email from Whitman, and the attachment that you have in your hand was the second one.
Okay, so all this is the email?
That came in via email,
Okay.
yes.
Okay. Sorry. Okay, I will now read the emails that have been submitted. The first one is from Bill Palace. And he lives at, I don't see it. Oh, I don't see an address. I noticed the notice of public hearing posted on 1579 East Ashley. I've owned the property at 1719 East Ashley's for many years and have run, biked, and traveled East Ashley countless times over the years. I would much prefer any new structure built on 1579 to comply with the 10-foot setback as the President ordinance defines. The lot at 1579 seems to be a challenging lot to build on, considering how our high tide mark always seems to be eroding further inland. And then our regular beach renourishments keep trying to mitigate that erosion. I assume the owner's request for consideration of a 5-foot setback variance is to either build a larger home or to keep their new structure further back from the inevitable beach erosion. I have witnessed the inevitable erosion many times on the 14-foot superfront homes that have been built since the 1990s on the east end of the island. My opinion, being a longtime Folly Beach property owner, would be to have the city enforce a 10-foot setback and not grant the 5-foot variance. Granting a 5-foot variance may set a precedent for future ordinance challenges. There's also a letter from Cassie Pittman, who lives at 1630 East Ashley. Hi, Ms. Stevens. I'm a resident at 1630 East Ashley. I'm requesting this variance not be allowed. If this is allowed for a 5-foot setback, more owners may ask for this. A 10-foot setback keeps Folly within the beautiful yards and curb appeal we want to keep. Please do not allow this 5-foot setback to be allowed. And lastly, from Sheldon and Christine Litwin, please find attached a letter detailing our strong objections to the appeal for a variance from the zoning ordinance 165.
What you were holding earlier
Yeah.
was the attachment, okay.
.01 -02 for the property at 1579 East Ashley. The letter provides multiple strong arguments for why the appeal should be denied. It is clearly not in the spirit of the ordinances, which are designed to protect the beauty, integrity, and small community feel that is crucial to the continued livelihood of our quaint island. Giving in to such an unreasonable request ultimately hurts all of us that cherish Folly Beach and recognize that the beach is in fact the lifeblood of the community and the island. We trust that the City Council will recognize the untenable nature of the request by the developer and deny the appeal. And then this is the attachment. I'm writing to protest in the strongest possible terms a request for an exemption from current zoning standards for the property located at 1579 East Ashley. The developer is requesting an exemption that would allow the property to be constructed a mere 5 feet from the road. This request should be denied due to aesthetic, social, environmental, safety, and economic concerns. The quote below is taken directly from the Visit Folly.com website. Folly Beach, South Carolina is one of America's last true beach towns. Just minutes from historic downtown Charleston, Folly Beach is a 12 square mile barrier island that is packed with things to do, see, and eat. This is a funky, laid-back, come-as-you-are kind of beach. The pace is invitingly slow, the people are captivatingly unique, and the shops and restaurants will receive you with good old-fashioned Southern charm and hospitality. It won't take long for you to feel right at home. The idea of building a house 5 feet from a highly utilized roadway is anathematic to the funky, laid-back, charming beach town that is portrayed by our website. A house directly abutting the road is something we would expect in a crowded urban area, but not on a quaint beach cherished by locals and visitors. Approving this request will open the door for every developer to push houses closer to the street. If this is approved, there will be no alternative but to approve all future requests. It would show favoritism to approve this one, but not subsequent similar requests for exemptions. Older, smaller homes will be torn down and replaced with large homes that will only fit on the available lots that are up against a street. Approving this will forever change the character of Folly Beach. It makes it a desirable place to live and visit. Not only would this violate the spirit and ethos of Folly Beach, but there are other significant concerns. This lot is too small to build on. There is severe beach erosion there. The prior plans for this lot were approved with the stipulation that if the beach erodes to the point where the habitable structure is on the beach, it must be removed at the owner's expense. This was done for the obvious reason that the building would pose a hazard as the inevitable beach erosion and hurricanes occur. This new request is obviously an attempt to get around this stipulation, as it makes a house unviable. The lot contained an active turtle nest this past year. See the picture. Building on this small piece of native dunes will make it forever after unusable by the turtles. Losing additional dunes in order to build a house on a lot that is too small is unacceptable trade-off. The septic system will pose a risk to other species that live on the beach when the lot is breached by floodwaters, which is inevitable. The Morris Island Lighthouse is one of the most iconic landmarks in Charleston. Traveling on East Ashley Avenue is the only way to access views of this historic, beautiful piece of Charleston history. Hundreds of thousands of people travel this road on a daily basis. Everyone driving, riding, walking, scootering on East Ashley will have to see this disgraceful eyesore every time they go by. It will detract from the ambiance and appeal of the island for both residents and visitors. It will become its own landmark that everyone will recognize in an unfavorable way. Below is directly from the City of Folly Beach website. The beach is our most important resource. It is valuable not only as a barrier against storm damage and as the economic engine of the city, but as a recreational area for hundreds of thousands of people each year and a habitat for a variety of wildlife. To make our beach best it can, the city must not only refine past practices, but search out new solutions and creative means of financing and maintaining beach management projects. The plan also reviews many of the city's existing ordinances designed to preserve and protect the beach. Examples include rules that govern lot coverage, maximum house size, setbacks, rules for non-conforming and non-compliant structures, multifamily development, minimum lot size has doubled to 10,500 square feet, new seawall ordinance permitting from the city, and rules for private dune walkovers. As a house this close to the road will obstruct views of the dunes and ocean for residents of the neighborhood and people passing by. The closer this house is to the road, the more it obstructs views. It is unfair to grant an exemption to one person when it negatively affects property values of existing residents. The lot size is marginal for the proposed house and not in the spirit of the ordinances. The building of a new seawall should not be allowed due to further destruction of the beaches. If the intended use of the new house is as a rental property, it is unlikely that there can be enough parking available for renters with this house so close to the street. Moreover, it seems likely that existing parking on the easement would be compromised by the house being so close to the road. There are genuine safety issues having a house this close to the road. The road's already narrow. Any larger vehicles, especially trucks, construction equipment, etc., will have a hard time getting past. In addition, there are no sidewalks anywhere along the road or any other road on Folly. Many pedestrians, cyclists, etc. use East Ashley Boulevard on a daily basis. A house this close to the road poses a special danger to those legitimate users, as they will be forced to travel in the roadway rather than having a place to move to the side of the road. Perhaps most importantly, emergency vehicles, especially fire trucks, will have difficulty traversing this narrow section of road and certainly could not turn around there. For all these other reasons, we implore the City Council to deny this unjustified request for major zoning exemption that will open the door for future development that is poorly thought out and detrimental to the community. The only rationale for approving this request would be to produce financial gain for one person at the expense of many others. Please give serious consideration to the long-term consequences of this decision. That's it.
Is there anyone else who did not sign up to speak, who would like to speak?
Sir?
Yeah, my name's Randall Sandin. I'm the real estate agent for Mr. Vaslow, and I own 510 East Huron. And so I feel as a property owner at Folly Beach, I do have the right to talk. And I think a lot of this is a little bit about property rights. The lady that owns the property has owned it for decades and has paid taxes to Folly Beach for decades, and she has the right to be able to do something with her property. And the fact that Mr. Vaslow is going to buy it through his company, he has the right to do something with the property. We know most neighbors don't like houses being built on vacant lots on Folly Beach. It's a pretty common occurrence. But especially in this case, with there being a past history of pocket lots and how they have to work and to be able to make it so that it's buildable, I don't think what they're asking for is out of the ordinary, and I think you should grant the variance. Thank you.
Thank you. Anyone else? Okay, at this time, we'll hear any rebuttals that the applicant would like to make to the testimony that's been presented already by the staff or the public, and you'll have 5 minutes.
Thank you, Madam Chair. Members of the board, very quickly, I'll just kind of run through these points as quickly as I can and to be very direct. Precedent, just talking about setting a precedent for these kind of variances. There's no precedent to be set by Board of Zoning Appeals. You don't set a precedent. Each lot has to be looked at and meet 4 criteria set out in state law. If you don't meet those criteria, you don't get a variance. The ordinance also has those criteria in it. Our application puts forth the reasoning why this lot meets those criteria. There's no precedential value for granting a variance to one lot. As far as the baseline, there was Mr. Davis made a comment about the baseline survey in 2024. Folly Beach is exempt. Folly Beach baseline will not move. Folly Beach baseline has never moved. Folly Beach has a baseline that was set because of the jetties being constructed in Charleston Harbor. Folly Beach does not have a setback line. Every other beach in the state has a setback line. Folly Beach is unique. That baseline will not move. 2024, 2031, 2038, it isn't moving unless the legislature changes the law, and I don't think Folly Beach is going to let that happen. The perpetual easement line and the dune renourishment is also subject to federal regulation and federal easements. Those easements were given to the town of Folly Beach. On this lot, it was taken by eminent domain by Folly Beach. We cannot get it back. There is no construction taking place on a dune. The drawings that were submitted indicate the toe of the dune that was flagged by OCRM, by the state regulators. All of this construction is landward of that dune. That dune falls completely within the DMA that this city passed, and we're staying out of that. With regard to a seawall being built, seawall can't be built. Seawalls are prohibited by state law. There will be no shore parallel seawall built on this lot. It's against the law. You cannot get a permit to build a seawall in this state or put rock shore parallel in this state on the beachfront. It's not allowed. With regard to encroachment on the road, as I've said before, the 5-foot setback is, the 5-foot encroachment is an encroachment into the front yard dimensional requirements of the zoning ordinance. It is not encroaching into the right-of-way. If the right-of-way is 75 feet, the road is not 75 feet wide. If South Carolina Department of Transportation decides to widen East Ashley, which is a state road, it has 50 feet. The city of Folly Beach has an additional 12.5 feet outside of that 50 feet on this side of the property. There is no encroachment into that area. There will be no impact to the right-of-way or to the road. The house will not be on the road. It will be away from the road. As far as parking, zoning ordinances require a number of parking spaces. Mr. Baslow has designed his home to provide all of the required on-site parking. There is no septic encroaching on the side setbacks. There was an inference that one of the drawings shows that the septic system will encroach on the neighboring setback. That is incorrect. The drawing shows an area that's shaded in gray is known as the repair area. That is an area that has to be repaired post-construction so that it can maintain the side setbacks. It will be planted, it will be landscaped just like everybody else. Temporary impacts in that area is simply from construction. It is not a permanent encroachment. The septic system cannot encroach into the side setback without a variance. We're not asking for that. The septic system is designed to stay wholly within this lot's setbacks. With regard to turtles, there has been a photo showing turtles nesting on the ocean side of the primary dune at this lot. That's not in dispute. This house is not going to be on that dune or ocean side of that dune. Sea turtles, Caretta, the green turtle, stops at vegetation. Does not go up on top of the dune and lay its eggs. The mothers come in, hit the dune, the change in elevation. If there's no vegetation, sometimes they will crawl over it. If you look at the photographs, the primary dune of this is vegetated. These turtles do not nest where the home is being built. Otherwise, they'd be nesting all over East Ashley. They go between every house, if that's what they did.
Your time is up.
Thank you.
Thank you. Okay, it's time for motions and discussion. Do I hear a motion to grant the variance as presented?
I make a motion to grant the variance.
Thank you. Do I hear a second?
Second.
Thank you. Now we can have our discussion. During discussion, members may ask questions of the staff or applicants. Before ruling that discussion is complete, the chair can ask if anyone disagrees with the facts as stated in the staff report. Does anyone have any questions? I have one, and bear with me, I'm just a dumb nurse, but what is adverse possession? For whoever brought that up.
I'm happy to take a stab at it because I got a case in court right now. Adverse possession is a common law principle whereby if in this state you hold land owned by someone else for a period of time, you can claim ownership of that land. You have to prove that in court. You have to meet certain criteria. There are 6 criteria you have to satisfy. You have to get the judge to rule in your favor that you have had continuous, hostile, open, actual, notorious, and exclusive possession of that property. For 10 years under the state statute, it's 10 years, but that can't be transferred. If it's through different property owners, it has to be 20 years. You have to have held it and made it clear to everybody that you were claiming ownership of someone else's property. That's generally accurate.
Okay, thank you.
Can I ask for help?
Sure.
Thank you. The rock wall that extends down the center of the property lines between 1581 and 1579 it goes into this property. There has been no legal claims to the adverse possession, but it has been there for 30 years. It's obvious. It was in the plats that were submitted to this city with the rock walls to get the permit by OCRM. The designs that I showed you that were submitted to OCRM, don't believe my lying eyes, but it shows the septic tanks into the 10-foot setback line. Maybe they amended them. We have no other plats to that effect. Maybe so. The plat that I showed you shows the septic system into that setback line, and that intrudes on those rock walls. If those rock walls are removed, then this property adjoining this lot will now have the effect of being erosional. It was built to protect it from erosion. Same thing with the other side. I don't know where they are, but so if they have to take that rock wall away to build a septic tank, they actually damaged this person's property by making it exposed to the active beach, the way the South Carolina OCRM describes this lot as the active beach, so that we know that because they can't build a rock wall by law from 1988 and amended in 1990. They can't build a rock wall to protect a house. Any flooding that comes into it is going to affect whatever septic tank's built. And if they have to remove the walls to put the rock revetment wall to protect or to build a septic tank, now any flooding will intrude on this neighbor's property.
Okay, thank you. Can I ask staff to clarify, does the septic not go into will it cause the rock wall to be removed?
Yeah,
So-
may I point this out?
I
So
prefer
a couple of
to
important
have the
things.
staff.
There's a 5-foot sideline setback mandated by DHEC. And I'm Aaron Pope, city administrator, former acting zoning administrator when this was happening. So DHEC mandates a 5-foot property line setback. The 10-foot setback Mr. Walker is referring to is a zoning setback for above grade construction. So the presence of, and I'll let these guys explain the drawing, but if the drain field of the septic system was within the 10-foot setback, zoning wise, the city doesn't count that. The only setback for septic tank is a 5-foot setback from the property line. For clarification.
Okay.
In the presence of the rock wall, that's a private matter between two adjoining private property owners. So we can't take the presence of their wall on these guys' property. When we review for zoning compliance, we don't review for the presence of private encroachments on each other's property. So staff can't speak to the presence of the wall.
I got you. What we have here is two different sides. One side saying it does encroach on the septic does encroach on the rocks, and the other side says no, it doesn't.
Yeah, and the presence of the rocks is not a zoning consideration of the city. The presence of the rocks is a private matter between adjoining landowners.
Madam Chair, may I respond just quickly with regard to the drawing? There seemed to be some confusion as to what the drawing shows and whether or not we've changed it.
Sure.
If you look at exhibit I believe it's Exhibit B to the applicant's package. It's a plan of the site. It's right next to the, y'all might not have it in color, but yeah, Mr. Rosenbaum.
Go ahead.
The septic area and septic field is depicted on the northwest side of the property. If you're looking at the property from East Ashley, it would be on the right-hand side of the proposed home. There is a gray kind of cross-hatched rock-looking area. That is the drain field for the septic system proposed by OCRM, approved by the State Bureau of Water, DHEC. The dark gray shaded area is area that is inside the 10-foot setback. That is shaded and colored as repair area. That is when the septic system is being put in, there may be impacts in that area from having to access it. That area is not part of the septic system. That will be covered back up with native material and not there. If you drive a track hoe through there, you're gonna tear up the land. That's just to be repaired. So we're depicting the repair areas. This septic system sits 10 feet off the property line.
Okay, thank you.
Are the rocks in that picture?
No, they are not. If you look
Something
on
says
there,
bulkhead or something?
it says bulkhead, and those bulkheads actually create an erosion problem. They may be protecting the next door neighbor, but they damage everybody that's landlord of that lot by creating a channel. FEMA doesn't allow that anymore. If high water comes up, you have a high flood, that becomes the channel for the washout to take out everybody behind it. The presence of the Corps of Engineers dune is what mitigates that.
Does anyone else have?
The only other-
a question?
I'm just, since how far the house is actually going to sit back from the road, there's a lot of different discussions, and one says, one thing, and one says the other. Do you know exactly how far it is from the road?
If I may, and I'm gonna have to speak in, I don't have an exact measurement. General roadway widths are 22 feet wide without surveying that road. In a 50-foot right of way, you would have 11 feet to the right of the center line, 11 feet to the left of the center line. So from that edge of pavement, one would do the math that it's
in this location, you have a 75-foot wide because of the two easements. So if you go center line, you'd have 35.5 feet on the south side of East Ashley before you hit the property line. And then the town variance says another 10 feet from the property line for the setback. We're asking to move 5 feet into that setback. So instead of being 35.5 plus 10, it's 35.5 plus 5 is the best I can do just based off of measurements. So if you remove 11 feet, as Mr. Basil says, we're talking about 25 and a half feet, 26 feet off of the edge of pavement.
Thank you.
I've got a question.
Go ahead, Emily has.
And this might not be a proper question or not, but we're talking about this, granting this variance is the only way to make it a buildable lot or to make it, him to be able to use it. Why does he have to have that big of a house? I mean, couldn't he slim down his house and still meet the variance requirements?
So, and I'll jump in for Jennifer first. So they have submitted 2 prior larger homes that were reduced to this, and this is what they feel is the minimum home.
I don't know why it has to be that minimum. I'm just trying to find,
Right, and
is that not
the task of the board is to decide whether or not this is the minimum use allowable.
okay.
Is that
But it's
based on?
3,000 square feet, right?
It's vertical.
It's
No.
3.
The square, the package explains this.
I added it up, but as a map there, it says 3,000.
No, I understand, yes ma'am, I understand what I'm.
I just see that as a reasonable alternative, I think, and that's what I'm asking you, is that not a reasonable alternative?
That's for the board to decide, but as the applicant noted, that is vertical square footage. The actual footprint is closer to 1,000 square feet.
It's larger than that.
I mean, staff thinks it's unreasonable. I mean, you've made the recommendation that you don't think they should have to, that's not an alternative. I mean, when I read your
We do believe that
report.
this applicant has substantially reduced their proposed structure into what is a small footprint. It is a reasonable use of this lot and the minimum necessary to make reasonable use of the lot. That is the recommendation.
Okay.
So it's like 1,000 square
Excuse
feet?
me, could you guys please tell the exact footprint of the structure?
Yeah, I'd like to know that.
It's on the other drawing, 1800.
1,800, somebody said?
So the first level is 900 square feet.
Yeah, on this page with the elevations, there's a tab, and the first level is 912 square feet.
I think it's this.
I read it somewhere else.
The document that noted, I guess this is from the special condition permit, but it was 1,435, was it prior?
That's 2 iterations ago.
So if you guys are still looking for that tab.
This is what I was looking at, right here.
It's the,
It's
It
this.
says first level 1435.
So that's from the special permit to the state. That's been revised downward
Okay.
several times.
Okay,
This,
that's what I was looking
this one.
Okay.
That's the actual proposal.
this one? Okay. So who's the homeowner? Is the homeowner? I thought so. Is there a reason you can't go back the net 5 feet and meet the criteria? You don't feel like your family could live in the house? It would be too small, or?
So we've looked at a number of different options, as
Right.
said, and what we've done, looking at circulation, what we argue is architecturally pleasing for the staircase, windows, not having a clear plane, a singular plane, but actually having it offset. You'll notice that actually only a portion of the house on that site plan is requesting that 5-foot variance. The rest is actually not requesting 5-foot encroachment to give it a dimensionality of it. So we did take all of that in concept.
Which part of it would be there? Where can I see that? I'm sorry, I didn't get a chance to look at this before the meeting.
Are the stairs gonna be closest to the road?
Yes, part of the stairs.
The front stairs?
The front stairs, they go
Is
into
it-
the
is it-
middle of the structure on the right-hand side.
Right.
And they do, a number of the treads do come into the
But
front yard.
it looks like the doors to the garage area, or the walls, is further away from the street than the front of the stairs, is that correct?
But the left side is out more.
That is correct.
So it's the stairs that are encroaching into the 5-foot setback?
No,
The
those
left
are-
part of the house also.
May I approach?
Sure, well,
So,
I'm looking at this.
okay, if you can look at the site plan, I can show the same stairs.
Oh, that's okay, I'll find it. Am I looking at this from East Ashley?
Yes, sir. And the stairs do come in here, but this portion right here, that is going in the setback. So the setback is right about that column. And this is coming up 2 feet into the front, and this additional 2.5 takes that plane into the 5-foot 6 plus.
May I ask the question again, because I don't feel like I got an answer
Yes,
to.
ma'am. Yeah.
Is there, I mean, what would be the detriment to setting back and meeting the 10-foot setback?
When we, again, I can't reiterate the number of hours and months.
I understand that, but, so what you're telling me is you've spent a lot of time, but you can't come up with a plan for a reasonable house that would meet the criteria for the zoning?
I believe that what we have done, I believe there could be millions of different configurations of houses, and there are push-pull on that. And the staff has heard me say this. We could come up with over 1 million different designs on this house. We could have a 1-bedroom house. We could put a porta potty on it and not request a setback. But what we have
You
done.
wouldn't have to do that to get the setback.
Well, but
That's a bit
as
extreme. Excuse me, I'm
as
sorry.
the staff has noted, our other plans, we've already reduced the square footage as well as the number of bedrooms in this house. And we spent a considerable amount of time looking at what the best flow is for the way people like to live today, including my family, and what we would like to have out here to use as a family beach house as well. And this is what we proposed.
So your family could not live with a house that was 10 foot from that had a 10-foot setback? Is that what you're saying? That would be a hardship on your family?
May I show this plan to you and the reason why for this plan on how we came up with that?
I just want to know yes or no. Is that?
Yes, ma'am. We looked at this and this is why we proposed it the way we did. Namely because of the stair system and maximizing the views on the ocean. And where that stair system, that circulation of the stair system alone is a 10-foot on the narrow side. Our original application actually had it flip-flopped and we were not requesting this setback. And in order to achieve where, again, the push-pull, where we had to put the septic for the state, where we could not encroach to not have requesting the further variances, this is what we were able to come up with that we found pleasing to us.
Okay. So the answer is no, you would not be, it would be a hardship on you if it was, okay.
I just don't understand. They mentioned they've used all these resources.
I'm sorry that y'all have already spoken it. We have to ask questions. The board has to ask questions, correct?
Yes, ma'am.
Yeah. Anybody else have, Mr. Rosen, did you have any questions? Kurt?
Yeah, not.
Yeah, I'm still a little confused. So I guess my question is, the bottom step, when I'm looking at the house from East Ashley, the bottom step would be on the right, stairway's on the right. Where is the 5-foot setback, or the 10-foot setback line relative to that first step?
So and please correct me if I'm wrong with zoning ordinance here, but the front facade of the house, exclusive of stairs, has to be within the 10-foot setback from the front of the property line per the zoning.
So the stairs are,
Everything has to be within.
You mean, beyond the setback?
Yeah, outside.
Not within.
It's not just the stairs.
Can I just remind everybody that I'm trying to make a record, so please one at a time, and thank you.
So the stairs also are subject to the setback requirements. And it looks like the stairs stick out at least 5 feet from the facade, front facade of the house. At least it does in this one to me. So is it only the stairs that are encroaching into this 10-foot setback?
No, sir, the front facade of the house is also.
So the stairs are going even closer. They're going inside the 5-foot setback.
Yes.
Okay. So if we granted a variance for 5 feet, the stairs are still non-compliant, I would think, if they go beyond, closer to the road.
They would have to turn to meet the 5-foot setback.
So they're not compliant the way they're drawn then.
Correct.
Okay.
Are there any other questions or comments?
I did have one other question. This is an easy one though. What are the red lines and the green lines on these?
Those are the South Carolina,
Excuse me.
those are already setbacks. What do you have, any question?
Not to the audience. We need.
Oh, I didn't know that.
No, I'm sorry.
I apologize.
But just in general, so questions need to be directed at staff or the applicant. Applicant produced this map. Here's the baseline.
The green line seen on this photograph is not, has nothing to do with setback or baseline.
Okay, so I can ignore that. Okay.
Yes, sir. The green line depicts just for edification, the green line on this and OCRM's picture is identifying what type or area of beach this is, whether it's a standard zone or an inlet erosion zone. So the red line is the baseline.
Okay.
And what this drawing was shown to depict is where that baseline was drawn on all existing structures to make sure that they didn't cross any neighbor's properties. The pocket lot that we're talking about is shown, and if you look at some of the other ones, you can see the other 4 pocket lots on Folly Beach that all have homes on it.
All right, thank you.
Thank you.
Yes, sir.
Any other questions from the board? Emily, did you? Okay. All right, I'm supposed to restate the facts decided on by the BZA in granting or denying the variance. And I think the only fact we came up with was that the stairs are in an additional intrusion onto the setback, whereas the side of the house is 5 feet, but the stairs would be even closer than that. Any other facts anyone else feels we've come up with? Okay. At this point, I will,
If you're authorizing a 5-foot setback, you're not approving the steps that are.
Yeah, sorry, just for
Go ahead.
clarity for the record, as the board is voting on a 5-foot setback, so if you guys do approve a 5-foot setback, that does not grant these guys permission to put steps further than 5 feet. Their steps will have to fit within the
they have to
setback
figure
you
that
approve.
out themselves. Okay,
If you vote for a 10-foot setback, then
Right.
okay. I guess at this point, we'll ask the secretary to call the roll. Oh, I'm sorry,
So
I
why
keep
you
looking
gonna
at the secretary.
Ms. Cato,
No.
Ms. Denninger,
No.
Mr. Gunn,
No.
Mr. Miller,
Yes.
Mr. Stevenson,
He's not here.
Ms. Brown,
No.
Mr. Rosen.
Yes.
Can we do it one more time? Ms. Cato?
No.
No. Ms. Denninger?
No.
No. Mr. Gunn?
No.
Mr. Miller?
Yes.
Yes. Mr. Brown?
No.
And Ms. Brown and Ms. Rosen? Mr. Rosen?
Yes.
It does not pass. 4 noes, 2 yeses.
The motion to grant the variance has not been approved, has failed. The decision was based on the following facts. I guess the fact that, the group felt that it should, adhere to the zoning laws as they are posted. The board has denied the request for a variance. A copy of this decision, as well as the supporting findings of fact, will be made available to the applicant and become part of the record of these proceedings. That's it. Thank everyone for being here. Mr. Rosen, I'm going to ask you.
Hey, Trey. You thought it was 7? Mine says it's 7. You know, I thought it was 7. I looked again, and actually my calendar said 5. And so when I got the minutes, it said 6.
I think these minutes.
They didn't come.